Okay. Agenda item 704, Supreme Court / State Bar Blue Ribbon Commission on the Future of the Bar Examination. And I understand Ms. Chavez will be presenting this.
Mr. Chair, this is Sonia Dellen.
Yes.
I would like to inform the board and the chair that I would like to recuse for potential personal conflict for 704 and 705.
All right.
Thank you.
Thank you.
Hi, good afternoon, everyone. This is Lisa Chavez. Can everyone see my screen?
Yes.
Yes, we can.
Okay, terrific. Thank you. Hi, good afternoon again. I'm Lisa Chavez. I'm the director of ARIA, the Office of Research and Institutional Accountability. At your board meeting in May, you directed staff to form a Blue Ribbon Commission for the future of the California Bar Exam in partnership with the California Supreme Court. This commission would take up larger long-term policy issues pertaining to the bar exam, such as issues pertaining to content and format. This agenda item asks you to adopt a charter that will guide the commission's work and approve the proposed composition and size of the commission. Staff will work with the Supreme Court to finalize the charter and appoint the members. The proposed charter and the commission composition is an attachment A to the agenda item. So as a reminder, the background to this work is that the CAPA working group submitted its final report in May of 2020 of this year, and they looked at the results of the CAPA analysis and recommended that the California Bar Exam test for 8 legal topics and 6 skills. Also in May, you heard of the results of a series of studies that were either commissioned by the State Bar or conducted by the State Bar. And the National Conference of Bar Examiners will be issuing its final report on a job analysis that it's conducting this year. So the commission's charter is very straightforward. First, they are asked to review the CAPA study and the working group's recommendations, as well as other materials and studies relevant to the bar exam. And after they've conducted that review, they are to develop recommendations on whether and what changes to make to the bar exam and whether to adopt additional testing or tools. So to delve a little bit deeper into each of those, the first question is, should California adopt the uniform bar exam? In particular, this is where they will look at the results of the CAPA analysis, look at the CAPA working group's recommendations, and look at the results of the NCBE study, and ask if there's sufficient alignment in between what California entry-level attorneys should know and be able to do versus what is going to be recommended for the UBE. If the commission recommends that California adopts the UBE, then the commission should recommend whether or not California should have some supplementary content and skills to be tested, and if so, how they should be tested. Another question they will be considering is whether California should revise the California Bar Exam. And in particular, they are to make recommendations with regards to the legal topics and skills to be tested, and then provide specifications for supplementary testing or training for topics recommended for inclusion on the exam and exclusion on the exam. They should also make recommendations for testing format, any changes there. And also they should review the passing score, review its appropriateness and whether it should be changed. So the composition of the commission will be 16 members that will be appointed by the Supreme Court. We're committed that this commission will reflect the state's demographic and geographic diversity in attorney practice sectors and settings. At least one will be a lawyer who took the bar exam within the last 3 years, and nominations will be drawn from the following entities and stakeholder categories. Here they are. And that's the number from each category. And the timeline is that this group will begin their work in fall of this year, 2020, and present a final report on its findings and recommendations no later than June 30th, 2022. That's all I have. Any questions?
Thank you very much. Any questions for Ms. Chavez? Right. Well, thank you for that very concise and informative presentation. I appreciate it.
Thank you. You're welcome.
Is there any discussion among the board? I do have one question, and this perhaps should go to Ms. Hershkowitz. We've heard comments by a number of people in the last few public comments that we've received, certainly with the applicants to the bar that occurred on July 7th, and even this morning, questioning the efficacy of a licensing exam in this format in the first place, which I suppose is the fundamental and threshold question, whether it's whether the answer may or may not be supposedly self-evident or not. I'm not sure. But would that inquiry come up within the charter as we understand it, Ms. Hershkowitz?
So I think that's a fabulous question, and I think that's something that could be teased out specifically in the charter, that the recommendations would address specifically. We can say sort of the whether a bar exam, we can figure out exactly how to wordsmith it, but whether whether a bar exam is the right tool to determine minimum competence for the practice of law. And then go after that, sort of go through the other questions. If the answer is yes, then you go through the other questions. If the answer is no, then you would develop other ways to test minimum competence. Lisa sort of gets into those other ways when she talks about if we, we should look at other supplementary testing or training for topics not on the bar, but that assumes that there is a bar exam. So I think we can build in that essential first question of whether the bar exam itself is the appropriate tool for testing minimum competence, and if not, then what should be administered in place of a traditional bar exam?
I think I would suggest that we may want to consider making that one of the topics that's specified, and perhaps topic number one, which is a consideration of whether a licensing examination in the manner in which we have traditionally presented it, whether it's remotely or in person or anything like that, putting that aside, but that type of test that we've been using is the best, most efficient and efficacious way to determine basic competency for entering attorneys in this day and age. So,
and I think that you could also add a tail onto that question. I think there are certainly those who would say that that the transition from an in-person bar exam to an online bar exam was something that was bound to happen at some point in the future. Nobody expected to be in the position that we are right now with the pandemic. And so I think it's been forced on a lot of states more quickly than they would have been ready for, but it's certainly a possibility that might be part of a licensing structure in the future. And so, so I think the consideration of whether a licensing exam is the best way to determine minimum competency should also question the modality of that. So whether that exam is administered in standardized testing centers or standardized testing venues or through a remote approach.
okay, well, I probably be prepared to offer that language to that effect as a friendly amendment. So is there any further conversation or discussion about the resolutions as they are presented, or my meandering rumblings about a possible friendly amendment? All right, then, hearing no discussion, I would suggest that we have a motion to adopt as presented, and then I will try to work with Dag to come up with, or Donna to come up with some language on the fly to insert that as well. if we need it. That would be,
Is that
Although,
in a
no, I don't-
resolution?
I don't think we need it. I don't think we need it in the resolution. We just add it to the list of topics. Does that work?
Yeah, I think we would just say where it references in the first part of the resolution, it references attachment A. I would just say as amended.
Very good. Okay.
This is Jose. I'll make the motion.
Thank you. Moved by Mr. Cisneros. Second.
And Stallings second.
Thank you, Mr. Stallings. Seconded by Mr. Stallings. And I assume that that's with the amendment as we've put it in there to attachment A. Is that correct?
Yes.
And Mr.
Correct.
Stallings. Okay, thank you. Any further discussion? All right, please call the roll.
Broughton,
Yes.
Chen,
Yes.
Cisneros,
Aye.
De La Cruz, Dellen is recused, Duran,
Yes.
Iglesias,
Yes.
LeBron,
Yes.
Manning,
Yes.
Portula,
Yes.
Peleg,
Yes.
Stallings.
Yes.
The motion as amended carries.
Thank you. All right, the final agenda item on the open agenda is 705, consideration of issues related to the postponement of the July 2020 bar examination. And I understand that Ms. Hershkowitz is going to present on this, but I also understand that Mr. Stallings needs to recuse himself from this conversation. And Mr. Stallings, do you want to be removed from the room, so to speak, and head on over to the closed session, or do you want to stay here?
If I could be relegated to attendee, that way I'm stepping away from the table in a Zoom sense.
Very good. Please relegate Mr. Stallings to that place where he should go.
Mr. Chair,
Yes.
also I am recusing. Same way as Mr. Stallings.
Okay. Please transfer Ms. Dellen too, but be more gentle. Her transfer.
Who knows? It might be more fun where they're going.
Yeah. What are you saying? What are you implying? All right, 705. I believe, Donna, Ms. Hershkowitz, you're going to take this one on?
Yes, so I want to take this opportunity to provide an update to the Board of Trustees about the status of where we are on the decision-making for the status of the bar exam, or more correctly, where the Supreme Court is. At the time that the agenda was developed and was posted, we were unsure if the court's final determination would have been issued, and if so, if it would have necessitated board action. If that were the case, then we would be talking about some specific board action at this time. The court has not yet issued its final determination, but its release is imminent. So at this time, I did want to provide a little update, and I might get some support from our chair or from Josh Portula on this. But I just want to let you know sort of what's been happening and what could happen in the future. The State Bar has been working in close communication with the Supreme Court about the options that you have all heard and read about, that have been emailed to you and presented to you, including the issues that were raised today by many of our public commenters. In balancing the needs of public protection and the significant, cannot state that enough, the significant impacts on law graduates and others who are trying to gain admission to the State Bar of California, we really have been looking very closely, and the court has been looking very closely at all of the issues that have been raised, the challenges with the many different options. Obviously, along with the applicants who you heard today during the public comment session, the bar and the court both would have liked to have made a final decision long ago. But with the changing conditions, including the limitations recently announced as to specific dates when an online exam can be held, and the need to thoughtfully consider the bar's mission and the reason for the current requirements related to admission to the practice of law, there is just simply no easy decision, and there is no perfect solution. Many states are actually making or revising decisions as we speak. In fact, just a few moments ago, the news came out that the state of New York just released its decision to cancel the September bar exam, having previously postponed that exam from July. And at this time, the state of New York has not announced alternate plans since they are not having a September exam. That's not to justify the fact that we don't have a final decision. It is to explain, however, that many states are finding themselves in the same place that California is, where we are really trying to evaluate what is the best thing to be done for the applicants who will be taking the test and for the public that we are charged to protect. Again, one of the things that I certainly want to make sure that we are clear about in all of our communications, I know all the board members know, the final decision on this does not belong to the bar. The final decision belongs to the Supreme Court. And we have been working extremely close with them as this process has moved on. A couple of recent events, frankly, to talk about where we've been communicating closely with the Supreme Court. Back on July 2nd, 3 justices from the court, a few members of the Board of Trustees, a member of the Committee of Bar Examiners, and some staff here at the State Bar met with about 45 law school deans to get the input of the deans on the decision that the court had to make. The week after that, on July 9, so a week ago today, we held a webinar, a Zoom webinar with bar applicants. We notified everybody who'd registered for the bar, which at that time was about 10,500 applicants. Right now, that number is actually closer to 12,000. But we notified everybody about the meeting, and about 2,700 people showed up. We took comments from about 100 bar applicants at the time. The Chief Justice, Justice Cuellar, and Justice Liu were present for the meeting, as well as, again, several trustees and a member of the Committee of Bar Examiners and State Bar staff. And again, to hear the input of the applicants and the direction that they think is the way to go and the challenges that they think are they would face, the challenges we would all face with any of the other options that are under consideration. As you've obviously heard today, a large percentage of the applicants favor a diploma privilege, and we're very clear with the bar and the court on the challenges that they believe would exist with an online exam or an in-person exam or anything short of the diploma privilege option. I would like to note that there is, and understandably so, a fair amount of confusion and misinformation out in the public sphere about what an online exam is, as to the requirements, the impacts of internet instability, the tools available to use in a remote administration, etc. Amy Nunez had tried to allay some of those concerns in some of the meetings that we had with the deans and the applicants. I know that that Alan talked a little bit about some of that today, talked about the AI and the concerns that people have about AI and the biased algorithms that are built in, trying to assure folks that the AI is just the first sort of round that is identifying possible issues. And then there are several layers of human review that follow the AI. But because there is so much misinformation and confusion, if the Supreme Court were to direct the administration of the exam happen remotely in an online manner, we are prepared in short order to issue an FAQ to help folks understand what the exam would be like, what those challenges are, what the issues with internet connectivity are, why an MBE would be provided, et cetera, sort of the questions that we've been hearing that we hope, again, should this be a direction that the court recommends, we would like to allay fears if that is something that is needed for us to do. Again, I do expect a decision from the court imminently. Because we don't know what that determination is. And Sarah, at this point, if you could sort of post the resolution, because we don't know what the determination of the court might be. And I expect that there is going to be some real need for the board to be able to act swiftly and decisively. I just while we were sitting here, threw together some language that I'd like for the board to consider that would provide us some resources, board resources and board oversight immediately. And so you see what we're proposing is that Josh Pertula would work with staff on efforts related to an online bar exam, should there be one, and Hayden Chen to lead implementation efforts related to any other direction that the Supreme Court may provide. And then you see the further resolve that that the board would delegate to Hayden Chen the authority to appoint a working group or take other steps that are necessary to implement the direction of the Supreme Court. The reason, just so you know, that we divided this out between two folks is Josh has been working in this capacity with staff in the initial run up to the baby bar and sort of where we are today in terms of the decision making on the exam, and he's developed some real expertise on that. And I would love to continue to have his eyes and his thoughts and those that he has pulled together to help with thinking through that. But we know, that I want to make sure that if I'm looking at multiple things, that I'm not spreading Josh too thin, and that we'll be able to have a good division of labor if there are multiple options that we need to be examining and doing so quickly.
All right, any questions for Donna? Josh, do you have any comments you'd like to make?
Yeah, no questions, but a couple of things. One, folks, this is, as everybody knows, and they could hear from the public and the applicants earlier, is a really complex issue. One in which, although it might not always seem to everybody, but the staff has taken, not ignored a single issue, not an email, not a phone call, not a request, not a public comment. It's been analyzed, it's been considered. It's a tremendously difficult time for a lot of individuals, and that's recognized. And we've tried to get the bar, I've watched, try to get the information to the court in a timely fashion, and the court to make a decision. And as Donna said, we're eagerly awaiting and looking for a direction. What I would really like to say, Alan, is the amount of work and the amount of dedication that Amy and the admission staff has put into this has been incredible. Long days and weekends and nights, and I commend them for it. I think everybody is moving and trying to do the right thing here, and it's very much appreciated on behalf of the Board of Trustees. I thank them.
Thank you. Yeah, I'd like to follow up on a couple of things that both Donna and Josh have said. First of all, Amy and her entire group have been working extremely hard, as we've heard, but just to give you a real example, over the 4th of July weekend, we had people working in order to get a certain project done. So people are rolling up their sleeves and really pitching in. Second thing, and from the staff especially. Second thing, I do want to thank very much Josh for volunteering to head up this working group of people that Donna appointed to put extra eyes on the entire process and get more board involvement. And along with Josh, Chris Iglesias and Mark Broughton have been attending these meetings and participating and been tremendous. So I want to take my my hat off to both of them as well. And Sean and I have been kind of ex officio hanging on, but the meat of the work has been done by Josh and his group. We don't know which direction the Supreme Court is going to go or what they may ask us to do. So what we have done is, and as Donna is recommending, is putting in place a placeholder committee headed by Highland that needs to be fleshed out once we find out what direction we're going. But it will be, if there is anything that they want us to look at, there will be tremendous time pressure and a lot of work to be done, and our resources are getting very stretched within the bar itself. So this will be a difficult task. Of course, we've got a great person to lead it in Highland, and any of you to whom she reaches out for help on that committee, I would certainly encourage you and hope that you would find your way clear to help. I know we have people, every one of you is working on various liaisons or working groups or this, that, or the other thing, in addition to just trying to keep up with all of the agenda items and understand all that's going on. But it is a critical time between now and this fall. And unfortunately, we're in a position where great things are required of this particular board. But I do want to thank each and every one of you for that. So unless there's any other comments or discussion, we should go back, I think, to the resolutions. Yes, Renee?
Yeah, I'm just curious why we haven't made it more clear to the audience that this is a Supreme Court decision. I felt today, I mean, I understand like the amount of angst and emotion. It just.
Well, I understand, and I understand your point, and it certainly comes across from the people who do speak and make their public comments that there is a lot of confusion out there. I will say that in every meeting that I've been in with the public, it has been made abundantly clear that the final authority here is the Supreme Court, and they will be the ones who will make the decisions. And I think that the leaders of some of these groups understand that. But I think somewhere as this information gets passed around, that gets lost. And since it's the state bar that's actually administering the test, we're the ones who seem to be deemed responsible for all of the decisions, not just the administration of the test.
Yeah, I thought maybe I was.
Yeah, you haven't missed anything.
Alan, if I may, just for Renee, I'd like to add that although obviously there are a lot of people affected and a lot that want to comment and want their point of view to be heard, it's not just the bar. They are also, and I can tell you, I know firsthand, advocating and voicing their opinion to the court also. So they do understand that.
Okay, thank you.
Yeah, thank you, Josh. That's a good point. Okay, any other comments or questions? All right, then let's return to the resolutions, please. And the chair will entertain a motion to adopt as presented.
It's Josh Pertula.
Josh Pertula moves.
Moved. Yep. With motion.
This is Jose, I'll second.
And Jose Cisneros second. Any further discussion? Okay, please call the roll, Ms. Cohen.
Broughton,
Yes.
Chen,
Yes.
Cisneros,
Aye.
Dela Cruz, Dellin is recused, Duran,
Yes.
Iglesias,
Yes.
LeBron,
Yes.
Manning,
Yes.
Pertula,
Yes.
Selig.
Yes.
Trustee Stallings' recusal is noted. The motion carries.
Thank you. All right, would you please bring back Mr. Stallings and Ms. Dellin from their self-imposed exile?